Good afternoon, everyone. First, I would like to congratulate the ADA on its 20th anniversary. It's really impressive to see how it brought together views from so many diverse interest groups for debate and discussion, and I'm very honored that you have invited me to share about Singapore's experience here. So the time allocated to me, I will give you a brief overview of the process, what we've gone through, what we're going to do next, and touch on some of the proposals that I think would be of interest to the audience. So looking at the overview of the process, we actually started the internal review of our copyright reform as far back as 2013, spurred on largely by what was going on in the UK, Canada, and of course here in Australia. After a lot of debate, we finally went out to the public in 2016 with about 18 proposals. And then in 2017, we held a second public consult strictly on copyright collective rights management, what was going on. It was a lot more of a fact-finding exercise. Over these two consultations, we had 3 public town halls. We had more than close to 20 engagement sessions with different industry segments, interest groups, academics, IP practitioners. We had in total over 100 written responses, and we had an online feedback form for the men on the street, creators, people who didn't really want to write lengthy briefs or pay lawyers to do that. So we had about close to 300 online responses. So we took about a year and a half to reach our decision on the positions, and we came out with a report in January this year, which I will be going through, and we are working on the draft legislation, for which we will also hold a public consultation, hopefully around the end of this year before we go to Parliament. So what were the objectives of the review? The title of this form is 2020, but we had to look back more than 20 years because our Act had not been comprehensively reviewed since it came into force, so for over 30 years. So like every other reform, essentially we're looking at rights that were reasonable, that were balanced, rights that were clear so that everybody in the regime understands what's going on, and of course efficient transactions. So users can seek permission to use works, creators and producers are able to reach their audience. But the more we embark on the review, what we realized was very important was like what Professor Guy said about the Canadian reform. It was to enable the consumption and distribution of works in the digital era. And well, it's a term we like to use in Singapore. We were trying to future-proof our Act, meaning that we wanted tech-neutral language. We wanted exceptions that were flexible enough that did not have to continuously catch up with what was the latest technological advancement or the newest business model. So these were principles on which we based our review. So we went out in 2016 with 16 proposals. So you can see here, they are pretty far-ranging. They're addressed from the point of view of the creators, proposal number 2, number 4, number 5, and then we talked a lot about limitations and exceptions as well. And then the second consult was on a collective rights management landscape in Singapore. And in the process of the public consultation, a topic came up which to our attention, and the rights holders were constantly talking to us about the streaming of audiovisual content from unauthorized sources through set-up boxes, what you call grey boxes or illicit streaming devices. I know Australia also has that situation, and so we addressed it in our policy report. Okay, and I thought I would just go through these proposals because definitely there will not be enough time to go through every single proposal, but the slides are available, the report is online, so you can go through in more detail at your leisure. So the first topic we had to address was whether we were going to establish a voluntary copyright registration system, and in a nutshell, the answer was no. Singapore is a small market. There are already, our National Library already has a legal depository for all kinds of works. We found out that a lot of corporates, and especially those in the entertainment media field, were already using the US Copyright Registry. 2 very important points came out from the engagement sessions. A lot of the men on the street think that the copyright registry is to confer ownership or confer protection, which is not exactly correct. And because it's voluntary, there's a lack of comprehensiveness. And this is an important point, was also the expectation of paying incredibly low fees. So that meant was the cost-benefit analysis was basically not in favor of a voluntary copyright registration in Singapore, but we are still continuing to monitor what's happening, especially at the WIPO level and even at the ASEAN level, as to whether we can even have a ASEAN level kind of copyright registration system, copyright depository system. Right, should a right of attribution for authors and performers be introduced, and how long should the right last? Currently, under Singapore's law, we only have the right to prevent a false attribution of your work. So this was something that we felt was very important, especially in social media, where everybody is sharing photos, blogs, information without attributing who is the creator. And we also had a spate of cases in Singapore where corporates were actually using artistic works, paintings, drawings, sculptures by artists, and not attributing who the creator was. So we decided to create this new right of attribution. We had to strike a practical and reasonable balance because one of the principles of our review was efficient transactions. So essentially, the right will be personal, not transferable, and it will last only for the duration of copyright protection. And we will not apply it to certain works where it is impracticable to do so, like computer programs. We took a lot of reference from the right of attribution regime in the UK. These are some of the defenses that will apply for this right, like can be waived in writing, reporting of current events, and of course, the courts should have the discretion to award an appropriate remedy, taking into account the facts and circumstances of each case. Very importantly, we have to look at what was the defendant's behavior. Was it truly a malicious omission of the name of the creator, or something that was an oversight, and the practicalities and cost of compliance. Fair use, which I think would be of interest to all of you here. So when Singapore introduced the fair use exception in 2004, we added a fifth factor to the US-style fair use. We didn't even call it fair use, we called it the general open-ended fair dealing exception. And we added in a fifth factor, the possibility of obtaining a work within a reasonable time at an ordinary commercial price. Back then, it was meant to deal with the fact that we're dealing a lot more with physical copies. But times have changed, everything is almost really available, but as said by the presenters earlier, not necessarily accessible, or you may not even be able to license. But we also felt that by adding the fifth factor from a lot of consultations and a lot of discussions through the public town halls, that people were misconstruing the essence of fair use. So you had intermediaries who said, so long as you could get a license, it is not fair use. And you had creators who felt that as long as I can show I couldn't get a license, it is fair use. So until it became like the whole fair use defense was based on the fifth factor, which is actually not what fair use is about. So we will actually remove it, but removal of this fifth factor does not mean that you do not need to consider. It simply means it's not a statutory mandatory factor. It can still be considered in relevant circumstances, and we had some case law commentary that in a way it is a consideration of the fourth factor, which is what is the market impact. So, and we decided that because we finally had our first fair use case in 2017, where the Court of Appeal said that US jurisprudence would be considered, we decided, heck, we might as well call it fair use. Everybody calls it fair use anyway. So we're going to term it fair use. And Singapore has a hybrid exceptions regime where we have this general fair use provision, and we follow the UK in having very specific fair dealing defenses as well. So we would need to come to some kind of logical way of streamlining and categorizing them in our Copyright Act. Orphan works, which I know that you are consulting on here as well, we put forth to the public 3 models for an orphan works register, so essentially what we went out to the public was we want to create an orphan works register. What would be the prescribed model for calculating and payment of compensation? So these were the 3 models that we came up with, surveying what was going on in the UK, and the UK, US, and also what was being proposed here in Australia. The interesting thing was that there was a lot of debate of all 3 but the consensus was that none of them were ideal. One of the concerns was government interference, setting, the tariffs, the license fees, and concerns also as to whether we really had the expertise to set the license fees, because often works would straddle so many different categories of works. How are you going to build up the expertise? Would you hire in experts, train up your own officers? And on a study of the orphan works registries in other countries, the volume transaction was not exactly high enough so again, it was a bit of a cost-benefit analysis. But we also took a step back and looked at our entire review and what were the other exceptions that we were creating. As I was explained later, we were expanding the exceptions available to heritage institutions as well, and they were the largest calls for an orphan works exception. And we felt that what the exception we were creating for them would actually deal with their needs vis-a-vis orphan works. And then we had fair use to deal with cases where you would love to adapt or repurpose or do something transformative in orphan work. And then there was a third category where you simply wanted to reproduce the orphan work for commercial benefit. And we felt for the third category, they could manage their own commercial risks. So we felt that the current regime could sufficiently address the orphan works issue. So for now, we will not be having any orphan works register or statutory limitation, but we will monitor how the exceptions for the heritage institutions and how fair use will apply over the next few years before we look further into this issue. And of course, we will be observing what's going on in Australia on that as well. Now, we also are proposing an exception for text data mining, and we followed very much the UK provision, but where we went one step further was that we said that you could use it for commercial activities as well, because for the UK, it stopped short at non-commercial activities. But we felt that it was not practical to draw the line, and it would also prevent research institutions from commercializing their results. But we would weave in additional safeguards that you must have lawful access to the works and you may not distribute what you're using for text data analysis to those without access. And rights holders can also take reasonable measures to maintain the security and stability of the computer system or network. Education, which I think is a topic that is of great interest to all of you. Now, when we went out in 2016, we were looking at a pretty wide purpose-based exception for the giving and receiving of instruction, regardless of media or platform of instruction. And as expected, there was a lot of pushback from intermediaries and the publishers. And there was a lot of discussion with the publishers as well as the Ministry of Education and the various schools as to exactly what is the current pedagogy and method of instruction. And the thing is that schools as Professor Guys also alluded to in his, actually he said quite expressly in his presentation, are moving more towards online usage. Even in peer-to-peer learning where students do their projects or share information, it's largely online. Schools are actually subscribing to online portals set up by the publishers themselves. My son is in primary school, and every week, we had to log into the online portal by some publisher to do all his worksheets. There's very little hard copies nowadays. So we do not want to affect commercial relationships. If the schools have an online subscription to a portal, please go ahead. We didn't want to also affect all this, the collective management organizations, arrangements with schools for the photocopying of printed materials. But we felt what was important was to allow access to online works for teaching and sharing for education, but only if the online work is accessible without the need for payment at that time. And it must be for an educational purpose, and it must be on behalf of or on the premises or otherwise in connection with a not-for-profit educational institution. So if you run a private school for profit, you cannot benefit from this exception. Beyond students and teachers, we also extended it to government officials who perform curriculum or content development functions. And you have to acknowledge the source of the online work, and you should not use work that you know or reasonably to know is infringing. and rights holders may use TPMs to restrict access to their works. So this was a very heavily nuanced, negotiated outcome of the exception, but I think it made both sides pretty happy with the outcome, and we will see what happens. Another exception that may be of interest to all of you is that for the GLAM institutions, essentially we created a new exception in our Act. I mean, we proposed to create a new exception in our Act for exhibition, but it's only accessible to museums and galleries that are not for profit or displaying items from the national collection and non-profit libraries and archives. The materials that you wish to use for exception must be in the permanent collection, and there must have been a reasonable investigation that a copy could not have been obtained at an ordinary commercial price. We are also proposing, at the request of these heritage institutions, to allow copies of the same materials for publicity materials, but with restrictions that it must be at a level that may not be a reasonable substitute for the work itself. And if they were to charge fees for, like, the art catalogue, the exhibition catalogue, it must be at a cost recovery basis. Now, we have existing exceptions for libraries and archives for preservation, research and study, which is based in very archaic language and which the libraries have told us is almost impossible to understand. So we are going to try and simplify them. But more importantly, we are going to update it for the digital economy and also extend it to museums and galleries. So wherever our exceptions reference copy, it would mean digital copies and copies of digital copies. And we would allow preemptive preservation copying, such as where your original format is obsolete or becoming obsolete, you may actually copy it into another format for preservation. But all this risk mitigation against preservation, the making of copies, cannot increase the copies available to the public. If you wish to increase the number of copies available for circulation, then you need to go back to the publishers and negotiate accordingly. And we will extend this to non-profit museums and galleries as well. Contract restrictions, which a lot of countries are looking at. We had a tough time with this. When we first went out, we had a long list of exceptions, and everybody said we were practically making every exception not to be overridden by contracts. We essentially, on deliberation, came down to two principles. One is that an exception has already taken into account the balance between the rights of owners as well as access for larger public interests. And so we did not want to undermine certain exceptions through the use of contracts, judicial proceedings, professional advice, libraries, archives, museums, and galleries. One of the major feedback they gave was that there were too many contracts, too many exceptions, it was hard to manage. And so if we create the exceptions for preservation and then we allow contract to override, they'll be back to square one and not able to manage. So for these type of exceptions, it would not be overridden by contract, and we applied it to the exception for data analysis as well. So what about all the other exceptions? To lend certainty to users, we introduce a new we are going to introduce some kind of a legislative framework to make an assessment as to whether a contract term can override. Freedom of contract means you must have had freedom to contract in the first place, so we will not allow it to override an exception if it was unreasonable. Where a contract has not been individually negotiated, then it will be considered unreasonable. And if it has been individually negotiated, any exception could be judicially determined to be unreasonable, and we will have a set of statutory guidelines for the courts to base their determination on, from which we will take reference from the Unfair Contract Terms Act. Speeding through, on the second consult on the collective rights management landscape in Singapore, because of all the feedback of lack of transparency and not knowing what's going on, after countless industry sessions, we decided to introduce a class licensing scheme. It's a very light touch scheme. If you fall within the definition of a CMO, you are governed immediately by a set of license terms and a mandatory code of conduct that is about principles of accountability, transparency, and proper corporate governance. The IP office, while it will administer the scheme, will not set any market rates. And as far as possible, there will be a series of self-help measures to settle disputes before it would come before us, for us to use our investigative powers. we could audit for compliance, impose financial penalties, remove recalcitrant management personnel and board members if there's repeated breaches, to the point that we could suspend, revoke, or reinstate licenses. And the last proposal that came not from the IP office but from rights holders of copyright content, broadcasters, cablecasters, was the prevalence of set-top boxes that allow you to access content from unauthorized sources. It was becoming a little bit rampant in Singapore, and we decided that, again, going back to the principle that where there is large-scale commercial gain, the government would step in. We would impose civil and criminal liability on those who willfully make, import for sale, commercially distribute or sell such a product. We did not want to inadvertently capture your smartphone or iPads. So it is very much more on the knowing element that the product was designed or made primarily for providing access to such content. It was advertised as providing access to such content, or sold as providing access, because we had cases where the retailer would sell an empty setup box and then later give you a slip of paper with a website where you could go to add in the apps, or even for a further fee help you to upload the infringing content. Right, and so our civil and criminal liability would be also imposed on such behavior. So that, in a nutshell, is our policy report. It's online if you wish to take a bit more time and go through it at your own pace. Thank you.